Hi, in this video I will be investigating what rights consumers have when they purchase digital products and how this is different to purchasing physical goods. First, I will explore what exactly consumer laws are. I will follow this by determining what goods and services really are, look into the case between the ACCC and Valve Corporation, and finalizing by discussing the differences between digital and physical goods. What are consumer laws? Generally, consumer laws are set out to provide both consumers and companies that are entering into an agreement together with extra legal protection to safeguard from any wrongdoings. Under the Competition and Consumer Act of 2010, Section 4B, a consumer is a person who purchases a good or service that is under a prescribed limit of $40,000. Let's say, for example, that a consumer purchased a new computer. If that new computer is faulty in any way, i.e. the power supply won't power the machine, these laws essentially give that consumer a right to remedy this situation. But what exactly falls under the category of goods and services? This is where some issues can arise from the perspective of digital products. So what exactly are goods and services? Well, goods are generally tangible items such as a car, a book, a phone, or even a clock. Services are intangible things like activities that someone provides to you. For example, going to a music festival, hiring a cleaner, using a laundromat, or heading to the movies. But where do digital products fit in? Originally, digital products did not fall under any category of goods or services in the Competition and Consumer Act. However, in 2010, the Act was amended to include the term computer software in the definition of a good. Unfortunately, this is not a catch-all for digital products and ultimately does not include products such as ebooks and digital music. This was recently confirmed in the case Australian Competition and Consumer Commission and Valve Corporation. The ACCC brought a case against Valve Corporation, the owners of Steam, a popular digital game platform, in regards to a misrepresentation to its consumers about returns of their games. Valve's defense was that digital games do not satisfy the definition of a good under the Competition and Consumer Act, and also, as a corporation established in the United States, that they were not subject to Australian consumer laws. Ultimately, Justice Edelman found that Valve Corporation did indeed supply goods under the definition of goods in the Act as a piece of computer software. However, the court also found that non-executable data was not computer software and did not satisfy the definition of a good and therefore had no subsequent rights attached. They also ruled that non-executable data could include music and HTML images, therefore not covering these items under the definition of a good. This leads to the problem of consumers who purchase such non-executable data or any other digital products that do not satisfy the definition of computer software not having the protections of these products provided by consumer law. The contrasting difference between physical goods, whether they are computer games in a physical form or any other products that satisfies the definition of a good under consumer law, and digital goods, is that the consumers of physical goods are entitled to the protections and guarantees of the law. Furthermore, the fact that retail shop owners of products that can be purchased digitally, for example books and ebooks, have to ultimately incur extra costs as they are required by law to honour consumer law. This makes retail costs go up and subsequently online retail costs of digital goods go down and profits go up. Essentially, they are subject to legal liabilities that digital goods providers are not, causing a gap in the consumer world. That brings us to the conclusion of the video. Thanks for watching, and I hope you have learned something.
Created using Powtoon.